out. My attorney, in a loud voice, enough to wake up the judge, concluded his cross-examination and said, "All right, madam, thank you. Those are all of my questions, Your Honor." The prosecutor added, "I have nothing further, Your Honor. Thank you." Judge Fournier told the counselor, "Merci, madame. You're excused." Judge Fournier also excused the French interpreter. Before adjourning the preliminary hearing so that he could review the evidence and testimonies presented in court, the judge asked me if I had anything to say or add before returning with his verdict. My attorney, Patrick, who stood beside me, whispered in my ear and instructed me to reply, "No," since anything that I said would be used against me during my trial. After answering the judge, he adjourned the preliminary trial and ordered us to return the next afternoon. It was now the afternoon of October 30, 2009. Judge Robert Fournier decided to have me continue to be charged with murder and to be tried for such in front of a jury. He did not care about the lack of a definitive cause of death and said in court, "The cause of death may be unascertained, but that is not to say that we cannot ascertain what happened and why." Furthermore, my attorney, Patrick McCann, did not convince the judge to consider the fact that he completely ignored half of the evidence. He fell asleep a quarter of the time during the preliminary hearing and ignored another quarter of the evidence since he did not like what he heard. Consequently, the legal requirement of intention, the second of two, with the first being causation, both of which are needed to justify sending an accused to trial for murder, was never addressed. Still, this is what Judge Robert Fournier stated in his written decision rendered on October 30, 2009, exactly 1 year before my wrongful conviction. This couple had been experiencing a great deal of marital difficulties, which included the fact that his wife had been seeing another man. As well, there is some evidence to indicate that Demetrius Angelus had undertaken a campaign of sorts aimed at discrediting, alienating, or marginalizing Leanne Lee Angelus in her role as a mother. From the lover's perspective, Ali Khan Nathu characterized those efforts on the part of the accused as parental alienation syndrome. To what extent such an endeavor might be established or even relevant is a matter I believe should be left to a properly constituted trier of fact. Nevertheless, the evidence also tends to indicate that Demetrius Angelus was taking on more and more responsibilities as a parent to the exclusion of his spouse. There are indications as well that there were disagreements over financial matters. For instance, Ali Khan Nathu testified that Leanne was of the view that large sums of money, in the thousands, had been removed from bank accounts without adequate explanation or justification on the part of her husband. In short, finances were another sore spot in this troubled marriage. In the end, it would appear that this was a failing marriage destined to end in separation and/or divorce. The court heard from police officers and paramedics in attendance. It seems that for a time the body of Leanne Lee Angelus remained on a carpet in the living room. It would appear that later the accused rolled her body in this carpet and moved her to an adjacent bedroom where the paramedics located her later and concluded she had passed away. In the days that followed, police authorities conducted their investigation. At first, in their efforts to elicit information from the daughter, the police were not successful. However, over the course of time, as we heard from several social workers in the employ of the Children's Aid Society, the child went from saying, "I don't remember what had happened," to disclosing more and more information about her recollection of the events. Needless to say, the reliability of her allegations and disclosures has been and may well continue to be a very contentious evidentiary issue in these proceedings. In that context, 3 of the workers involved in the care of this child have testified extensively in the course of this hearing. As the issue of credibility and/or reliability of this child's evidence is beyond the jurisdictional mandate of this judge within the confines of a preliminary hearing, I do not propose to elaborate further in that vein. I propose to focus instead on my actual mandate, which is to determine whether there is sufficient evidence in this instance to order the accused to stand trial on the count alleged. Hence, in this particular case, I must necessarily indulge in a limited weighing of the circumstantial evidence adduced with a view of determining whether a reasonable jury properly instructed could still return a verdict of guilty. The law is also clear that in the course of such an analysis, I must refrain from drawing inferences myself from the facts adduced before me, nor can I purport to exclude certain inferences in the process of this limited weighing exercise. It goes without saying that I cannot assess credibility. In the end, assuming that the prosecution's evidence is believed, I can only determine whether it would be reasonable for a properly instructed jury to infer guilt on the basis of such evidence in question. In that capacity, I cannot consider the inherent reliability of the evidence itself. To put it succinctly, my function essentially amounts to an assessment of the reasonableness of the inferences to be drawn from the circumstantial evidence. Finally, it is the totality of the evidence that I must consider in the context aforementioned. This brings us to the issue of causation and the legal principles which govern that particular narrow yet important issue. We all appreciate that causation in the context of homicide cases is comprised of two aspects, factual causation and legal causation. For the purposes of these deliberations, it would not be fruitful for me to indulge in elaborate considerations of those concepts. What is of greater interest to me in the context of this hearing is the principle of law raised herein by the prosecution, and that is the notion that the ultimate determination of causation is a matter of the trier of fact. In this case, the prosecutor alleges that there is sufficient direct evidence as to the cause of death, the mechanisms related thereto, and the nature of the assault, that no inference need be drawn, and that consequently committal is the only possible outcome. I am not sure that I can agree entirely with that proposition. However, in the event that an inference must necessarily be drawn, I am certain that it does not belong to me as a presiding judge in the course of a preliminary hearing to draw such an inference. My limited role is to ascertain whether such an inference might reasonably be drawn by a properly instructed jury. This jury will come to its own conclusions as to the credibility and reliability of the child's testimony. The background information and history leading up to this unfortunate event will also come into play during that jury's deliberations. Ultimately, this very jury will come to its own conclusions as to what happened in that living room on the 8th day of June 2008. Coupled with Dr. Paul Leonard's explanations, in my view, a properly instructed jury could reasonably infer from the evidence adduced herein that this is how the victim lost her life at the hands of the accused. Needless to say, this same jury could obviously come to a different conclusion, but it does not belong to me to say one way or another. What they infer from all of that evidence, what portions of it they ultimately believe and accept, is not a concern of this judge in this context. Finally, applying the knowledge and findings of the pathologist, this jury may or not be able to determine a cause of death. They might infer guilt or innocence. The only question I have to answer is whether such a jury could reasonably infer that the accused in fact caused the death of his spouse during the altercation which unfolded in the family's living room. My view is that such an inference could reasonably be drawn depending on the evidence, direct or circumstantial, which the jury ultimately adopts and accepts. Accordingly, Mr. Demetrius Angelis will be ordered to stand trial for murder. What a waste of time and money. The preliminary hearing did not yield any outcome except maintaining the status quo. My advice to anyone accused of a major crime in Canada is to forego the preliminary hearing and proceed straight to the trial. Clearly, presiding judges at preliminary hearings in Canada do not want to squash the initial criminal allegations regardless of what the evidence says because it is not within their legal jurisdiction to do so. When my father and I encountered my previous lawyer, Vincent Clifford, in the hallway of the courthouse after Judge Fournier's decision, even he was taken aback and wondered what happened. Although he did not say anything to us, I could tell from his facial expression that he blamed either my current attorney, Patrick, or Judge Fournier. I personally blame them both. The CSI effect played a huge factor, but not the only factor, in the Judge Fournier's decision during my preliminary hearing, but clearly it also affected the jury's verdict at my first criminal trial. The CSI effect was first described in the media as a phenomenon resulting from viewing forensic and crime-based television shows. This effect influences jurors to have unrealistic expectations of forensic science during a criminal trial and affects jurors' decisions in the conviction or acquittal process. The CSI effect has purportedly led to jurors' unreasonable demands for definite physical evidence at trial. With a rapid rise of interest in crime dramas across the world, there runs the risk of false expectations amongst the general population as to what forensic science can actually deliver. In adversarial systems such as in the USA and the UK, where juries are key to the process of deciding guilt, it is vitally important that when an expert witness presents his or her evidence in court, that there is an understanding of what is truly meant by the data presented and what is meant by the expert opinions conveyed. Many prosecutors complain that American fiction television shows like CSI, that is, crime scene investigation, make their job harder, as jurors demand ultra-high-tech tests to convict suspects. It has also caused some problems, and some of those problems are that people expect us to have DNA back in 20 minutes or that we're supposed to solve a crime in 60 minutes with 3 commercials. It doesn't happen that way, he says, but legal experts are concerned that juries may well be confusing fact with fiction. I think it makes it much harder for the experts. Juries now expect high-level science to be done on lots of cases where, again, we don't have the resources to do them, and in many cases the science doesn't exist to do them. Whatever the substance of the connection, lawyers, judges, and death investigators are acting as if the CSI effect was real. Some states now allow lawyers to strike potential jurors based on their TV habits. Judges are issuing instructions that warn juries about expecting too much scientific evidence based on what they see on TV. The CSI shows are potentially influencing jury trials where people's lives are at stake. In the field, Shelton says death investigators sometimes run useless tests just to show that they went the extra distance. They will perform scientific tests and present evidence of that to the jury, even if the results don't show guilt or innocence either way, just to show the jury that they did it. Our survey indicated that 46% expected to see some kind of scientific evidence in every criminal case. 22% expected to see DNA evidence in every criminal case. 36% expected to see fingerprint evidence in every criminal case, and 32% expected to see ballistic or other firearms laboratory evidence in every criminal case. The findings also suggested that the jurors' expectations were not just blanket expectations for scientific evidence, rather expectations for particular types of scientific evidence seemed to be rational based on the type of case. For example, a higher percentage of respondents expected to see DNA evidence in the more serious violent offenses such as murder or attempted murder, 46%, and rape, 73%, than in other types of crimes. Based on our findings, jurors were more likely to find a defendant guilty than not guilty, even without scientific evidence, if the victim or other witnesses testified, except in the case of rape. The bottom line is this. Our criminal justice system must find ways to adapt to the increased expectations of those whom we ask to cast votes of guilty. I would just like to point out that at the time, public records indicated that Judge Fournier's annual salary was over $253,000. That is not bad when you consider you can sleep a quarter of the time when reviewing evidence and testimonies while sitting on the bench. If my lawyer, Patrick McCann, had done a better job during the preliminary hearing, he would have made the judge feel compelled to reduce the allegation from murder to manslaughter, whether he liked it or not, thus allowing me to either be tried by a judge or a jury. Being tried by a judge is the better of the two options, since there is less drama and theatrics and more reliance on the facts and rules of law. Patrick McCann was angry with the judge instead of at himself for the result and told me that the judge was irrational and biased, although he did not specify if the judge was biased against him due to his questionable criminal past or due to my ethnicity. Regardless, it was clear to me that either way we did not stand a fair chance even before the preliminary hearing started. In any case, the news reporters were unable to provide their opinion due to a publication ban. I am inclined to believe, however, that Judge Fournier was more biased against me than my attorney, although even then, whatever bias he had against my attorney certainly did not help further my case to prove my innocence. About 2 months later, on January 9, 2010, Judge Fournier made national headlines. Accused credibility hurt in refusing to admit victim attractive, judge says. After convicting a hospital orderly, a recent immigrant from Ethiopia, for groping the breast of a blonde patient in the local emergency room and also brushing her thighs and buttocks and looking up her miniskirt, the judge used the man's denial in acknowledging the woman's sexual attractiveness as the basis for proving the man's lack of credibility in saying that he was innocent. Judge Fournier openly said in court that the woman was getting more service from this accused man than most of us get in a busy restaurant. The judge also stated, if 50 self-respecting, objective men who respect women, were to view this woman, however briefly, they would conclude that she meets the standards of an attractive woman, at least in the city of Ottawa. Here is a woman, relatively attractive, scantily dressed in a miniskirt, exposing her leg, and this accused refuses to acknowledge that he noticed her. In my view, this is virtually impossible. After the accused's lawyer, Daniel Nugent, argued that it was illogical that the accused would risk his job by sexually assaulting a patient, Judge Fournier quickly replied, why does Tiger Woods, the successful professional golf player who was married to a stunning blonde woman with blue eyes, see 14 women? I can't figure that one out either. Clearly, Judge Fournier is biased in favor of blonde women with blue eyes.